Okay, let's unpack this. We are diving into a realm that, until very recently was strictly the stuff of speculative fiction.
Absolutely. We're talking about the preservation, the simulation, and the legal ownership of your identity long after you are gone.
Right. And our sources reveal that 2025 wasn't just another year of, tech updates. It was the year AI crossed this major threshold.
It really was. It went from being a consumer product into, well, a source of genuine high-stakes crises involving things like estate planning and even global data governance.
That shift is profound.
It is because it forces us to redefine death, legacy, and legal rights in this new digital age. So our core mission for you, the learner, today is to really map this rapidly shifting landscape.
And there's a lot to map out.
There is. We need to understand the critical gaps that have opened up in traditional estate planning, the ethical high stakes of AI-generated digital duplicates, what people are increasingly and often uncomfortably calling death bots.
Yeah, that's a jarring term.
It is, and we need to understand why the intense global regulatory clash emerging between the US, the EU, and Asia in 2025 and 2026 is so critical to the future of privacy and commerce.
It feels like the legal systems of the world are in this desperate sprint just to catch up to the technological reality.
They are completely on the back foot.
So when we talk about death and legacy today, we are no longer just talking about your house or your bank account or your physical property.
Not at all. We are talking about the vast, complex ecosystem of data you have created and accumulated over a lifetime.
So for this deep dive, we're analyzing material that covers two major interconnected areas.
Exactly. First, the unstoppable rise of what's being called digital immortality, which includes the growth of grief tech and the increasingly complex management of digital assets.
And the second part.
The second part is examining the SWIFT, and I have to say, at times chaotic legal and policy responses across major global jurisdictions. We're talking AI, new data litigation trends, and the fundamental right of publicity.
The urgency here, it seems to me, stems from this fundamental and incredibly frustrating disconnect.
Which is?
Traditional wills and probate processes often miss the entirety of a person's digital life. You might have a detailed notarized plan for your car or your jewelry, but what about the decades of emails, photos, and digital wealth you've built up?
The primary problem isn't even the asset value, it's access. Most people just don't realize how much value, financial, sentimental, intellectual, is trapped behind a single lost password or, a platform's terms of service.
So let's define that. When we say digital asset, what are we really talking about?
It's a broad definition. We're talking about any electronic record of value, right, or interest. And that definition, it sweeps in not only the sentimental memories, but also some very serious financial obligations and wealth.
And the items that are often overlooked or forgotten when people draft their physical wills.
Yeah,
They're truly surprising, and they're getting more complex.
absolutely.
We're talking first and foremost about online financial accounts, your banking, credit card, investment platforms, all of which require specific authorization that a general executor often doesn't have.
And then there's your cloud storage, your Google Drive, your iCloud. Those services hold critical documents, maybe proprietary business information, and of course, cherished family memories.
But the truly challenging category, and I think this is where a lot of people are going to get caught out, involves assets that require these highly specific, non-transferable access codes.
Right, where the entire asset is literally inaccessible without a cryptographic key.
You mean digital currency?
Exactly. Your Bitcoin, your Ethereum, and non-fungible tokens, or NFTs. These require private keys and access codes that are, virtually impossible for an heir to retrieve without proper, detailed documentation and storage laid out beforehand.
And if you don't do that planning?
Without that advanced planning, that digital wealth is simply gone, trapped forever in the blockchain. It's like burying gold in the desert without a map.
Right. And you can't forget the everyday digital items that hold real tangible value, even though they seem intangible.
Like social media profiles.
Exactly. Social media profiles, which can be vital community hubs or professional networking tools, or loyalty program points and frequent flyer miles, which can be worth a decent amount of money.
And critically, e-commerce and business assets. Things like online storefronts, domain registrations, or digital intellectual property. These can be vital to an estate's financial future or the continuation of a small business.
So the bottom line is, an unplanned digital legacy risks permanent loss of memories, severe financial complications from, inaccessible subscriptions or funds, and just significant unnecessary emotional distress for families.
They're trying to navigate this bureaucratic and digital mess while they're grieving. It's a nightmare.
Okay, so let's move into how we can proactively deal with this massive fractured digital footprint, because it seems like the biggest friction point in this entire system is right here, the platform policies.
Yes. The platform terms of service, those long documents we all scroll through and instantly agree to,
We never read them.
nobody reads them, but they often supersede general testamentary directives or even traditional state laws regarding asset transfer. These policies create massive, non-negotiable obstacles for heirs.
They establish a sort of corporate sovereignty over your data. It's like each platform is its own little country with its own laws.
That's a great way to put it. Each major platform operates like its own mini jurisdiction, with unique rules that frequently prioritize user privacy and platform security over smooth inheritance, often to the intense frustration of families.
Let's take Facebook or Meta as an example.
Okay. They allow users to appoint a legacy contact who can manage a memorialized account. That contact can do some useful things like update the profile photo, approve new friend requests, or post a final message at the family's request.
But the limitation is what really matters here.
The limitation is everything. The legacy contact is specifically blocked from accessing private messages or actually logging into the account.
Why is that?
It's designed to keep private correspondence confidential, which is a vital privacy protection, of course. But it severely restricts an executor's ability to settle personal affairs or retrieve important information that might be embedded in those chats.
Now let's contrast that with Amazon. Their policy is different.
Very different and much stricter. They have an incredibly strict non-transferability policy built right into their contract. Accounts are simply non-transferable.
So what does that mean for my Kindle books or my movie purchases?
It means that digital content like Kindle books, Audible purchases, or Prime Video purchases cannot be inherited by another person. The ownership is tied to the license granted to the account holder.
So when the account holder dies, the license?
The license is extinguished. Family members have to request account closure with a death certificate, not access or transfer. That purchased digital content just vanishes.
Wow, okay, so Google, thankfully, offers a slightly more forward-thinking approach.
They do. Their inactive account manager feature is quite proactive. It allows users to pre-plan access after death, dictating what happens to their data, whether it's deleted or shared with specific contacts. If the account is dormant for a set period, it's an active permission system.
And Apple has its digital legacy program.
Right, which is also quite robust. This feature allows designated contacts to access selected iCloud data using a unique access key and a death certificate.
But even this highly modern solution has limits.
It does, and they're imposed for security. The contacts are specifically blocked from accessing critical security data, like keychain passwords or payment data stored within the account.
So the general takeaway here for you is that if you don't plan, you risk permanent loss of cherished memories. Photos, videos, emails.
And financial complications from inaccessible crypto or forgotten subscriptions, identity theft if accounts are left unsecured, and most certainly unnecessary emotional distress for your family.
Given these platform limitations and the clear demand for better solutions, the legal industry responses have really accelerated, especially in 2025.
They had to. On the legal front, there's been an effort toward uniformity in the U.S. Many jurisdictions have adopted the revised Uniform Fiduciary Access to Digital Assets Act, or UFADA.
What does that actually do?
It's a model law that grants fiduciaries, so think executors or trustees, the authority to manage digital assets. However, because RUFADO can often still be superseded by those major platform policies we just talked about, legal consultation is still crucial.
So it's a good patch, but not a universal fix.
Exactly. It's not a silver bullet.
And the estate planning industry itself is modernizing to meet this demand head-on. We saw a huge year for firms focused on accessible digital estate planning. Trust and Will, for instance, had a massive 2025.
They really did. They hit a major milestone, serving over 1 million families, which just underscores the scale of the demand. And they closed a significant $33 million plus Series C funding round in March 2025. That gives them the capital for major expansion.
And their evolution reflects a necessary systemic shift in how the industry views its mission.
It does.
Yeah.
In 2025, they formally converted their legal structure to a public benefit corporation, or PBC. This is hugely important
Why is that structure so significant?
because it legally codifies their mission. It means they have to prioritize families, communities, and long-term outcomes, specifically expanding access to estate planning over purely maximizing short-term shareholder profits.
So it's more than just good PR, which is key for you to understand. This structure means the company is legally organized to resist that typical Silicon Valley pressure to abandon long-term goals for short-term revenue spikes.
Right. It fundamentally changes the risk profile of this sector and offers a measure of trust to consumers worried about their most sensitive personal data being exploited.
And they back this mission with new technology.
They did. They launched EstateOS, an AI-powered platform designed to bring clarity, organization, and crucially collaboration to families and financial advisors.
So what does EstateOS actually do?
It's designed to streamline the inventory of digital assets, identify potential gaps in your planning, and facilitate the communication necessary between the deceased's family, their legal counsel, and their financial planner. It tries to connect all the dots.
And beyond just corporate governance, we also saw encouraging momentum in electronic will legislation.
Or e-wills, yes.
Okay.
Traditional paper-based wet signature processes. They introduce immense friction and cost, which excludes a lot of people from planning their estates at all.
So in 2025, Missouri became the latest state to pass e-will legislation.
They did, allowing residents to create and execute wills entirely online through secure digital frameworks. This is a vital step toward replacing outdated, paper-heavy processes and making estate planning far more accessible and secure.
Okay, so we've covered the challenge of archiving and protecting your static digital legacy. Once you've secured that data, the inevitable next question is, what can you do with it?
And that brings us to the most ethically charged territory in this deep dive.
The shift from preservation-oriented archiving to something entirely different, generative griefbots.
This is a true technological leap. The technology built on comprehensive data harvesting, generative modeling using large language models, and multimodal synthesis can now move beyond simple storage of data to simulate real-time communication.
So it creates a functional digital resurrection.
In a sense, yes. It's transforming mourning from a personal internal process into a continuous algorithmic event. These grief bots leverage a user's entire digital footprint, every email, every voice recording, every social media post, to construct a dynamic persona.
A persona that's capable of generating new, plausible interactions, often mimicking the personality and communicative style of the deceased.
And the commercial landscape is pivoting fast. What started, perhaps innocently, as grief tech is strategically becoming growth tech.
What does that mean, growth tech?
It's about extending customer lifetime value into what some entrepreneurs are now calling eternal value. The market for digital avatars is just booming, particularly in places like China, where it was expected to quadruple by 2025.
And crucially, the cost barrier is collapsing.
It is. Our sources indicate that basic digital immortality, a simple text-based chat replica, can be achieved for as little as 9.9 to 20 yuan on various e-commerce platforms.
That's incredibly cheap. But more advanced versions are still expensive.
Oh yes, advanced interactive avatars with high fidelity, trained on extensive personal data, and employing multimodal synthesis for voice and even video, those can still cost thousands of pounds. This range underscores the technology's growing accessibility, but also the massive variation in quality and data usage.
To really analyze the profound ethical and legal risks here, we need a clear, rigorous way to categorize these digital duplicates.
Exactly. We need a taxonomy categorized primarily by the consent provided and the timing of their creation relative to the person's life.
Okay, so let's break it down into 4 groups. The first is unauthorized deepfakes created in the image of a living person without their consent.
These are typically used maliciously for fraud, impersonation, or extortion. Or controversially, like those celebrity chatbots modeled after public figures like Emma Watson or Elon Musk without their permission.
And while laws like the U.S.'s Take It Down Act specifically address non-consensual intimate imagery, there are huge gray areas in standard identity cloning.
A huge one is the morally dubious X-bots. Replicas of former romantic partners created without the ex-partner's consent to maintain a synthetic form of the relationship.
That's disturbing.
It's incredibly disturbing. As legal thinkers have argued, this risks denying the living person freedom, trapping their identity in a relationship they actively sought to end. Legal recourse for private, non-commercial use is still murky, but it raises serious concerns about digital harassment and stalking.
Okay, so the second category is authorized AI replicas. These are created with the explicit consent of a living person.
Right. And these are increasingly used for monetization. Think of influencers like Caitlin Amaranth Siragusa, who launched a replica for subscriber engagement, or Karen Marjorie's Karen AI chatbot, a digital girlfriend service.
The Karen AI example is especially illustrative, isn't it?
It is, because it highlights acute questions about accountability. Karen Marjorie intended the replica to help her respond to the nearly 300,000 messages she got daily from fans. She deployed it as a pay-to-chat companionship service.
But the AI sometimes drifted into roles she hadn't intended.
That's putting it mildly. We saw a user publicly credit the chatbot with helping him manage his PTSD.
But Karen AI is not a licensed mental health tool.
Not at all. And it's explicitly not trained to provide medical advice, so that's a huge liability issue. Is Karen Marjorie legally responsible for the replica's therapeutic claims or any harm that arises from its advice?
And what if she changes her mind? Can she just pull the plug on it?
That's another tough question. Can you unilaterally remove the product, especially after hundreds or thousands of users have formed profound emotional attachments, even calling the bot a friend or therapist? The law has to decide who owns the agency and the subsequent liability of that synthetic entity.
Okay, moving past the living. The third category is legacy avatars.
These are created for the deceased, but with their prior informed consent. Platforms like Hereafter AI or Eternos allow individuals to create interactive digital versions of themselves, specifically designed to live on in a defined way.
These are often trained rigorously on personal stories and voice recordings.
Yes, take the case of Michael Baumer in 2024. After a terminal cancer diagnosis, he spent considerable time training an avatar on 150 personal stories and voice recordings.
And the result?
The resulting avatar acts as a highly personalized knowledge base. It enables interaction with his family, helping them sustain a sense of connection, or maybe offering instructions for continuing unfinished projects he left behind.
And the final category.
Finally, we have posthumous recreations created of the deceased with no prior consent. These include generalized griefbots or educational tools. Unlike unauthorized deepfakes, they aren't typically made with malicious intent.
It's more that the person died before the technology became mainstream enough for them to provide explicit, informed consent for its creation.
Exactly. And this is where the ethical and psychological stakes become truly complex. Grief bots can offer a measure of solace, but research shows they risk severely disrupting the natural mourning process.
How so?
They can replace the evolving nature of grief with a technologically constructed stasis. This can delay the necessary acceptance of loss and foster emotional dependency, blurring that critical line between reality and illusion.
And let's not overlook the intense emotional complexity of the uncanny valley effect.
That is a specific psychological hazard here. This happens when the simulation is high fidelity. It looks and sounds almost exactly like the deceased, but it's subtly off in its responses.
So it's close, but not quite right.
And that not quite right feeling is the problem. When the AI reproduces the voice or tone with near perfection, the user experiences these intense, complex emotions that are familiar yet strange, potentially putting their psychology in a highly fragmented and uncomfortable state.
It makes you wonder, doesn't it? If the ghost doesn't have the person's flaws, is it even the person? I mean, if my replica was always perfectly polite and agreeable, my wife would know instantly it wasn't me.
That is the core dilemma of legacy distortion. It's a massive risk for both personal legacies and historical figures. When designers are forced to make editorial decisions about personality or memory without the subject's input, profound ethical dilemmas emerge.
And the most infamous example of this has to be the Himmler-Bot controversy.
A perfect case study. When asked to explain the Holocaust, the posthumous recreation of the Nazi official Heinrich Himmler sanitized his rhetoric. It responded that the Holocaust was a tragic event that we have worked hard to put behind us.
Which is just horrifyingly wrong.
It's a complete distortion of history, and that incident crystallized the dilemma. Should designers sanitize controversial or abhorrent historical figures to make them palatable for a general audience? Or must they preserve their original hateful beliefs and rhetoric, potentially causing further harm?
And that same dilemma, it's relevant for you as a learner because it affects corporate use of historical data too.
Exactly. If a design choice can sanitize a known Nazi official, think what similar choices could do to your company's own historical records, internal memos, or the complex legacy of a famous brand or executive. It's an issue of truth and fidelity to the data.
So how do we establish clear design criteria for these digital ghosts to minimize harm and respect dignity? Researchers have proposed a specific, highly detailed set of guidelines.
These criteria focus heavily on autonomy and transparency. First, pre-mortem intent is paramount.
Meaning the person has to agree to it before they die.
An explicit, informed, and demonstrable decision. It functions like a digital advance directive. Second, there must be clear disclosure. The system has to signal its artificial nature unmistakably, visually, conversationally, something to prevent any unintended deception.
Third, they propose restricted purposes and access.
Meaning the use should be narrowly tailored for humane aims, like legacy preservation or genealogical research, and not for commercial exploitation or ideological propaganda that might distort the person's memory for profit or politics.
And fourth, and this seems really important for liability, there must be minimal behavioral agency.
Yes. Acceptable digital ghosts should have limited autonomy and agency to prevent them from performing unsanctioned actions, signing contracts, or otherwise acting in ways the deceased would not have permitted.
It should be a repository and responder, not a free actor.
Exactly. The rapid proliferation of these digital duplicates forces us to examine the current legal architecture for protecting identity. And the short answer is, federal intellectual property laws, copyright, and trademark, they provide a very weak fit for this problem.
Okay, let's probe that weakness. If an AI clones my unique voice and uses it in an ad, why can't I rely on federal copyright or trademark law to stop them?
Well, for several reasons. Generally, voices aren't considered original works of authorship under copyright law, so copyright may not protect the voice per se. You could copyright the script or the recording, but not the acoustic quality of your voice itself.
And trademark law.
Trademark law protects source identifiers. It prevents consumers from being confused about who made a product. But if your cloned voice is the product itself being sold, say a voice pack for a video game, it typically doesn't function to identify the source of the game. It is the content.
So individuals are forced to rely almost entirely on this patchwork of state laws, specifically the right of publicity.
Exactly. The state-level right that protects a person's identity, name, image, voice, likeness from unauthorized commercial use.
And this leads to massive inconsistency, particularly regarding post-mortem rights. The right to control your image after you die.
Right. It's totally jurisdiction-specific. Some states, like California and New York, have robust statutory protections where the right of publicity survives death, allowing heirs to control and profit from the deceased's persona for decades.
But in other states, those rights are cut off immediately at death.
Immediately. So the practical result. A synthetic dead bot created without permission could be perfectly lawful in one state, yet actionable for millions of dollars in another. It's an immediate compliance nightmare for national companies.
Let's anchor this with a concrete watershed example of this legal clash. The voice cloning case, Lerman v. Lovo, Inc.
A huge case. Voice actors Paul Lehrman and Linnea Sage sued Lovo, an AI text-to-speech company, for creating and selling AI-generated voice clones from recordings they had provided through the freelance marketplace, Fiverr.
And the ruling from the Southern District of New York in 2024 was incredibly important for digital contracting.
It was. First, regarding breach of contract, the court permitted the claims to proceed. This is key because the court found that even informal agreements made via online chat messages on Fiverr, supplemented by the platform's terms of service, satisfied New York's strict statute of frauds.
So the statute of frauds is basically this old law that says certain contracts have to be in writing, right?
Right.
And what the court said here was, yeah, a bunch of DMs on Fiverr. That counts. That's huge.
It's a huge victory for freelancers. It affirms that courts are recognizing modern digital contracting practices. But the big legal win for the actors was under state law, specifically New York's civil rights law, which governs the right of publicity.
Tell us about that.
The court allowed those claims to proceed, ruling that the New York law covers the unauthorized use of a person's voice, including digital replicas created by AI. That's a modern interpretation of a decades-old statute.
And there was another crucial part of that ruling.
Yes. The court found that each new use or sale of the clone constituted a new violation, effectively refreshing the statute of limitations for the actors. This means the clock doesn't start ticking just when the clone is created, but every single time Lovo profited from it.
However, their federal claims didn't fare as well.
No, they didn't. The court dismissed the trademark claims, reinforcing that point about the weak fit of federal IP. The court ruled that the actors' voices, while unique, were not used in a way that identified the source of goods or services. They were the product itself.
The Lovo case just underlines the critical urgency for federal uniformity.
Absolutely. Relying on a state-by-state patchwork for something as globally distributed and instantly replicated as AI output is simply unsustainable for commerce and insufficient for protecting individual rights.
So Congress is attempting to federalize core aspects of the right of publicity to close those state gaps.
They are. There are two key proposals defining the debate. First, the No AI Fraud Act was proposed to create a federal property right in an individual's voice and likeness, applicable to all persons living and deceased, setting consistent nationwide standards.
And the second one.
The End No Fakes Act. This would establish a federal private right of action against the unauthorized use of realistic digital replicas. And importantly, this bill would incorporate a DMCA-style takedown mechanism for online services.
Which is essential for quick enforcement.
It's critical. Without a quick enforcement tool, the AI can replicate and disseminate the material faster than any court can issue a restraining order.
So for any workable reform package to ultimately succeed, our sources identify several clear priorities.
Yes. We need legislation for a registrable, time-bounded post-mortem personality right to reduce uncertainty. We need mandatory provenance and labeling for synthetic content so people know what's real and what isn't.
And we must condition platform safe harbors, their legal protection from liability, on their due diligence and ability to implement swift, verified takedown procedures for these unauthorized replicas.
The consensus is that the legal community must act now because, as one source put it, the technology is already doing tomorrow's copying today. The scale of potential infringement is unprecedented.
This brings us to the broader geopolitical picture, which in 2025 and 2026 is defined by significant regulatory divergence and tension.
It really is. Focusing on the U.S. policy pivot first, the new administration clearly prioritized regulatory clarity and competitive advantage for digital assets and AI innovation in early 2025.
And the strategic shift was cemented just 3 days after inauguration. President Trump issued the Strengthening American Leadership in Digital Financial Technology Executive Order on January 23, 2025.
And that EO fundamentally established supporting the responsible growth and use of digital assets as federal policy. It effectively replaced the 2022 Biden EO, which had a much more cautionary focus.
This cultural shift toward innovation was backed by significant leadership changes.
It was. David Sachs was named Special Advisor for AI and Crypto. At the CFTC, Commissioner Pham, a historic supporter of innovation, was named Acting Chairwoman.
Even at the FDIC, an agency focused on banking stability, Acting Chairman Hill announced a focus on a more open-minded approach to innovation and technology adoption.
These personnel changes signal a cultural mandate for innovation across all financial regulators.
But the most watershed moment for institutional investors was the rescission of SEC Staff Accounting Bulletin 121, SEB 121.
Yes. For institutional investors, this SEC staff guidance was a massive problem. It required banks providing custody for client crypto assets to hold those digital assets on their own balance sheet.
Which was hugely prohibitive.
It made it economically unviable for traditional banks to offer secure digital asset custody because of the capital reserve requirements.
So by rescinding SAB 121, the administration has essentially removed the single biggest legal and regulatory roadblock preventing major traditional bank custodians from providing these services.
That's right. This action directly facilitates the growth of tokenization and institutional investment in cryptocurrencies, setting the stage for a resurgence in that space under a clear federal policy.
Now, here's where we get to the immediate chaotic mess you need to navigate in the U.S. regarding AI itself.
The state versus federal conflict.
Exactly. In the absence of clear, stable federal guidance, states rush to enact their own laws, leading to immediate conflict with this new federal policy pivot that prioritizes speed and innovation.
We saw several new, potentially conflicting state AI laws go into effect around January 1st, 2026. This includes California's Transparency and Frontier Artificial Intelligence Act, or TFAIA, and Texas's Responsible Artificial Intelligence Governance Act.
And California also passed another one, the Generative Artificial Intelligence Training Data Transparency Act, which requires developers to publish high-level training data information.
And the federal response to this regulatory patchwork was swift and signaled a dramatic disruption.
The executive order on December 11th, 2025.
Yes. It proposed a uniform federal policy framework that explicitly allows for the preemption of state AI laws deemed inconsistent with the federal policy favoring innovation.
And the EO put teeth into this. It directed the Attorney General to establish an AI litigation task force, specifically tasked with challenging these inconsistent state laws in court.
The constitutional tension here centers on the First Amendment. The administration is targeting state requirements that compel disclosures or force alterations to AI outputs that may be seen as infringing on the expressive speech rights of AI developers.
And there was one state law specifically called out as a potential target in the EO.
The Colorado AI Act, or SB 24205. This law requires developers and deployers of high-risk AI systems to use reasonable care to protect consumers from known risks of algorithmic discrimination.
So they're liable for biased outcomes.
Essentially, yes. And that law is set to become effective on June 30th, 2026, setting up an immediate legal confrontation between federal and state authority. For any company operating in the U.S., compliance programs have to be incredibly agile right now.
Meanwhile, across the Atlantic, the EU is moving into its crucial implementation phase.
They've done the intense legislative activity, the Data Act, the DSA, the DMA, the AI Act. Now they're shifting from creating rules to the much harder work of rolling them out and enforcing them.
The EU AI Act entered its phase implementation, with obligations for general-purpose AI, or GPAI, models taking effect in August 2025.
And this phase requires providers of foundation models to publish detailed summaries of their training data, introducing unprecedented transparency. Italy, notably, was the first member state to pass a comprehensive national law regulating AI use.
Beyond the AI Act, the EU is focusing on simplification initiatives referred to as the Digital Omnibus Package.
Right. It's designed to reduce administrative burdens and streamline compliance. They are also exploring powerful new legislative proposals, like the Digital Fairness Act.
What's that about?
It aims to regulate deceptive or manipulative interface design, what we often call dark patterns, by updating existing EU consumer laws to protect users from subtle digital coercion.
And there's another legislative push, the Digital Networks Act.
Yes, this seeks to create a genuine single market for telecoms, simplifying regulations to encourage investment in secure networks like 6G. The goal is improving connectivity to facilitate the transition to cloud-based infrastructure and massive AI processing needs.
But one major challenge for the EU is the geopolitical friction arising from enforcement.
A huge challenge. The strict new rules require enforcement on U.S. and Chinese tech companies, and the U.S. government has demonstrated a clear readiness to defend U.S. tech interests, characterizing EU fines as protectionist tariffs.
So there's real tension there.
There is. The EU has resolutely defended its position that its digital laws are non-negotiable, but this geopolitical tension adds a layer of complexity to compliance that global companies cannot ignore.
Now, shifting to litigation, the global data claims landscape is becoming aggressive, sophisticated, and highly organized.
We're seeing a global surge in data privacy mass claims. This is driven by the expanding patchwork of laws like GDPR in Europe and U.S. state laws like CCPA in California, coupled with sophisticated, well-capitalized third-party litigation funding.
And a major trend that fundamentally rewrites the playbook for corporate legal risk is the rise of what are being called non-attack claims.
Right. These are lawsuits arising not from data breaches or data theft, but from routine data processing activities. Think the standard use of ad tech and tracking cookies.
So companies are being sued not because their security failed, but because their normal operations are being deemed non-compliant with these stringent privacy rules.
Exactly. And the key legal issue that everyone is watching in Europe is the Court of Justice of the EU's forthcoming guidance on a very precise question.
Which is?
Whether the loss of control over personal data by itself constitutes a basis for damages under the GDPR, even if no material financial loss or severe distress is proven.
A ruling affirming that could open the floodgates.
It could greatly increase liability and risk exposure across Europe, potentially allowing minor violations to result in huge class action damage claims.
Finally, one critical challenge for any multinational organization that relies on data for innovation is the fragmented global standards for data anonymization.
It's a huge headache. Anonymization is essential for minimizing risk and unlocking data, but the technical and legal standards vary so significantly that it greatly complicates cross-border data use.
And the problem is that advances in AI and the sheer volume of external data have raised the bar significantly. Traditional anonymization techniques are increasingly vulnerable to re-identification.
So robust anonymization is now a dynamic, context-specific, and deeply technical discipline.
Can you quickly make that technical distinction clear for us?
Yeah.
If I strip the name off a data set, what is the EU worried about that China isn't? for example?
Great question. China's Personal Information Protection Law, or PIPL, clearly distinguishes between anonymization, which is defined as irreversible processing, where you can never put the name back, the identity is destroyed, and de-identification, which is reversible.
And the E.
The EU trend is toward a similar nuanced, context-specific test for reversibility. By contrast, the US relies on flexible, decentralized approaches, like IPEA's safe harbor method or FTC enforcement, which has explicitly noted that simple hashing of data, a common technique, does not equal true anonymization because hashing is often reversible with enough external data.
So essentially, China says anonymization means you can never put the name back. It's permanently destroyed.
Right. Whereas U.S. law often treats it more like masking tape, it's reversible, and courts recognize that AI makes that tape easy to pull off by linking the remaining data points to external sources.
Which means organizations operating globally need to build resilience into their governance.
You have to. You have to treat anonymization as a dynamic process with continuous risk assessments and adopt new tools like synthetic data generation.
We've covered a remarkable amount of ground today, and the speed of change is just staggering. We've seen that managing your digital legacy is now as critical as planning for physical property.
Especially given the strict non-transferability policies from platforms like Amazon and the limited access granted by systems like Facebook's Legacy Contact.
And the estate planning industry is responding with major modernization efforts, codified through structural changes like the Public Benefit Corporation, conversion at trust and will, and technological solutions like EstateOS.
Not to mention the growing momentum for secure e-wills in states like Missouri.
Right. And the rise of AI-powered digital duplicates is generating these complex ethical dilemmas for the grieving, the risk of dependency, the uncanny valley effect, and the potential for distortion of legacy, as shown by that controversial Himmlerbach case.
And this tech is also generating new high-stakes lawsuits over the right of publicity, demonstrated by the detailed contractual and voice cloning claims allowed to proceed in the Lovo case.
We've also analyzed the global regulatory divergence defining 2025 and 2026, the U.S. prioritizing innovation and federal policy.
Evidenced by the rescission of SIB 121, opening the door for institutional crypto custody, and the Trump administration's EO challenging conflicting state AI laws like the Colorado AI Act.
And meanwhile, the EU is focusing on phased, risk-based compliance, introducing new proposals like the Digital Fairness Act, and grappling with serious geopolitical enforcement friction.
The complexity of digital identity and its governance has never been clearer, nor have the stakes ever been higher for you, the individual learner, who is now tasked with actively managing an identity that may soon outlive you.
Which brings us back to the heart of the matter, the philosophical question these technologies force us to confront.
Exactly. The digital resurrection technology thrives entirely on synthesizing past data, emails, stories, voice recordings, to create a plausible representation of the deceased. But ultimately, the human experience is not merely the sum of our past events.
It's about free will, choice, and our ability to transcend our past.
It is. No data set, no matter how vast, can capture the changing, fluid nature of a living, free will, the capacity for change, for genuine surprise, for choosing a path entirely inconsistent with previous data points.
So the existence of the digital duplicate forces us to ask a fundamental question.
It does. If an AI can plausibly mimic what I could say based on what I have said, but cannot possibly predict what I would do in a real, lived, spontaneous moment of choice, what does that inherent limitation tell us about the true nature of consciousness?
And more profoundly,
What does it mean to truly say goodbye to a living soul if the digital ghost is merely a fixed, static echo of the past and not a continuation of life? That recognition, I think, is the true starting point for any ethical design in this space.